Okay, well, thanks. I think we're at part 3, are we?
Part 3. And just before we get on with it, I've had an update regarding helicopter. It is available to be booked any time for Thursday, and I'm told the weather should be better for Thursday as well. So if you'd like to get something there, let us know, and we can arrange to if you'd like to go out.
Where would you report to?
I can, well, when we report it, yeah, we can get all the details. I think it will go from the airport, I assume.
Yeah, I can see it this time.
Maybe it's just times.
Yeah, as I say, we're looking to visit a number of other properties in the morning, and we would be probably around midday about it.
Yeah, as precise as possible.
Precise as I can. We could obviously start our other site visits earlier to make sure we so, yeah, thank you. I think that would be helpful. Thank you for that.
Oh, we'll make arrangements. Thank you, sir.
So I'm just going to work through part 3. I'll go fairly quickly just because a lot of the stuff that I talked about in that section Mike's already talked about. So the first section, what information is required for a planning proposal as opposed to consent application. This is an issue that was raised by council to where certain bits of evidence that we talk about further information that's required. So the risk of acting or not acting is relevant consideration in evaluating the appropriate submission. However, the RMA does not prescribe any eventual threshold that rezoning submissions must meet. The level of detail that should correspond to the scale and significance of the anticipated effects of the proposal, and permitted analysis requires appropriate justification. I've referred to 2 cases. The first is Omaha Park 59, and the second is Save the Mai Tai at 60. Instead of just reading through this section, I might just refer to a couple of paragraphs from those cases. We have provided copies with our submissions, but I'll circulate those cases to AK as well. So the first is Omaha Park in Rodney District Council. And so that was a case involving a rezoning proposal for land south of Omaha Beach settlement on the Tapu Peninsula. One of the issues the court considered was the extent to which, if at all, the requirement for other regional resource consents for infrastructural requirements, particularly wastewater and water quality discharges, should influence the court in considering the plan change. And issues have been raised with the potential effects of sedimentation from stormwater runoff and on the feasibility of proposed wastewater treatment and disposal systems. There are 2 paragraphs that are particularly important. The first is paragraph 194, which I'll just read out. It says, having considered all of the evidence relating to the proposed infrastructure, it is our view that there is some uncertainty that Omaha Park would be able to obtain all of the necessary consents. However, on its own, we do not see that this uncertainty as being determinative of whether the zoning is more appropriate. The second paragraph is paragraph 259 of that decision, where the court said, we agree entirely with Mr. Green that the Act does not envisage that there will be no risk whatsoever. In this way, we've not gone deeply into elements of the potential sediment failure to the Whangatū Harbour, wastewater failure, or the risk of failure of the dam. Quite simply, the proposal has not advanced to a point where we could assess that risk, nor is there any occasion for us to do so, given that consents are required from the Regional Council. We have concluded that those matters could be addressed through the resource consent processes and can be put to one side for current purposes beyond broad discussion of the intentions in relation to them. For the same reason, we've concluded that the fact that water, wastewater and discharge consents might not be obtained at all is a matter that we do not need to concern ourselves unduly with at this stage. Although they constitute complications to the development, they nevertheless do not prevent us considering the zoning. And there's also another paragraph 159 of that decision, where the court agreed that the risk was on the applicant of not obtaining the necessary consents. The other case at 60 is the Save the Life High decision from 2024, and that was an appeal against the approval of the private plan change in Nelson. One of the main issues at hearing related to erosion and sediment control. And the applicant contended that there was insufficient information concerning potential in sediment from earthworks during establishment, and a consequent lack of understanding of sediment generation. The relevant paragraph from that decision is at 89, where the court said that the receiving environment was sensitive and highly valued culturally and recreationally, that the site was relatively low risk from an erosion and sediment control perspective. The structure plan had been developed incorporating a risk-based approach to the determination of appropriate zoning overlays, and that had been incorporated into the structure plan. That while there would be benefit in undertaking sediment risk modelling, doing that at plan change stage would involve a significant amount of speculation, and that the exercise may need to be redone once more detailed planning was completed for resource consenting, and that would not be either efficient or effective. And in that case, the provisions place an onus on managing the detail of erosion and control risks on the resource consent process. Given the risks associated and the approach in the structural plan, that was an appropriate way to manage residual risk. The court said that the obligation to have regard to actual and potential effects on the environment under section 76(3) was met, and that provision did not impose any threshold that must be met before a rule can be adopted. And therefore, it was appropriate to leave matters to be considered at a consenting stage, given the risk-based approach to the precinct. With the range of sectionalities taken as read at 64, just referred to set parts of the evidence. Lewisburg has spoken to some of those points and will speak to that in part 4. At 66, just rounding that out, uncertainty is a common feature of large projects that take time for detailed design and funding to be completed. And it's common for zoning proposals to ensure sequencing to coordinate with transport, water supply and wastewater infrastructure. Next section, what is the relevance of the spatial plan? At 68, the spatial plan was confirmed and finalised hybrid scenario growth scenarios D and E as the planning response to urban change pressures forecasted for the next 30 years, and the council is now seeking to retrofit the PDP to meet the spatial plan outcomes. CAFO accepts that the spatial plan is a relevant consideration that the panel may have regard to in making its decision submissions, and I agree with my friend's submission of that have regard to this genuine thought and intention. However, this does not override all other considerations, and the decision maker may give the matter weight they consider appropriate. Friends' submissions refer to a number of cases about the relevance of non-RMA documents, and from what I can see, the best that these cases say is that the documents is a matter to have regard to, and they don't elevate it to something that is binding. The Longview decision is interesting in that it says that having regard to the construction plan in that case is still to be done in light of the statutory instruments. And Mr. Duisberg has talked about our submission that there is no intensification imperative in the statutory direction in the PSUD for Tier 3 authorities or in SDUFD Objective 2. At 72, we talk about the preparation of the spatial plan having the same rigour as the Section 32 analysis, and the process being undertaken meant outcomes were skewed towards confirming the recommendation for scenario D and E. And in Appendix B, we've included a list of shortcomings that we have with the spatial plan. I won't go into a huge amount of detail, other than to note the first bullet point, and that comes from a consultation summary on scenarios D and E, and it records a question that was asked that says, do you support the draft spatial plan? Yes, no, and why? And the results were that 152 submitters said yes, and 165 submitters said no. So actually most people who responded to the draft spatial plan opposed it. In paragraph 72, we've included a reference to Mayor Mokotapania voicing his concerns about the process, the feeling that he had the council was lobbying towards a particular outcome. And in the footnotes, we've referred to the YouTube of that, the timestamp to where that was said. In our submission, we say there would be an error of law to elevate the spatial plan to be a touchstone for the outcome of the zoning submissions. Mr. Rubin's evidence appears to elevate the spatial plan to something that determines the outcome of the zoning, referring to conditions not being met, and that the scenario F being subject to future planning processes. Again, we say that these conditions do not bind this panel. And just thinking about the counterfactual, if Mr. Rubin was right, effectively what he's saying is that the spatial plan, not this panel, decides the rezoning. And we say that it's the higher order policy that the panel has to give effect to, and it's the has to conduct a Section 32 analysis. It's not, the spatial plan is not a replacement plan. In any event, the council has adopted a spatial plan that recognises the KFO site. And even with respect to these conditions, the evidence shows that they've been addressed, that they've been satisfied. The next section I've just got on the PSUD, and it relates to Mr. McElraith's evidence, the council's position that the PDPR provides sufficient development capacity in the short and medium term, and the long-term capacity is provided by the continued rezoning of land identified in the spatial plan, which the council considers is consistent with clause 3.41C of the PSUD. We don't disagree with that proposition that long-term demand can be provided for in a relevant plan or strategy under clause 3.41C. However, it is a technical sufficiency that masks the issue of affordability for detached dwellings. Mr. McElraith's evidence is that new standalone dwellings in the PDPR will cost $1.28 million, rising to $1.68 million by 2035. So while in the short term there is a technical sufficiency, it completely ignores whether the sufficiency is of a typology and a price that people can afford. And Mr. McElraith's evidence is that affordability only materialises in the long term. And Mr. Duisberg has talked about aspects of the PSUD that require affordability and typology to be considered, but again, it's an objective one. A well-functioning environment, and our submission is one that provides housing and typologies that people want at a price they can afford. And this is confirmed by policy A1, which says that well-functioning urban environments have or enable a variety of homes that meet the needs in terms of type, price, and location of different households. There's objective 2, which which says the MPS requires planning decisions to improve housing affordability by supporting competitive land and development markets. Objective 4, which is urban environments responsive to diverse and changing needs of people. And then policy 2, which says at least sufficient development capacity needs to be provided to meet expected demand. At least. So the options available to the council to make detached houses affordable in the short to medium term, and the answer is to rezone greenfields land. That was what the spatial plan said, despite what is now being said about the PDPR scenario. Council cannot rezone land in the spatial plan because there is no scope for it, and it cannot start the rezoning process until 2028 because of the plan stop. As my friend said, even then there is no guarantee the spatial plan will be implemented because neither the panel or the council can bind a future council to implement a plan change. Paragraph 79 noted that long-term supply can actually be provided by for zoning in a district plan. In our submission, that is the most appropriate outcome of this PDP. What the panel must do is weigh the risk of undersupplying capacity with oversupplying capacity. And we invite you to ask Mr. Thompson about this. But in our submission, the evidence is that the risks of acting and not acting fall in favour of oversupplying land and undersupplying.
Can I just ask a question? Again, just the legal submissions gelling in my mind. So is it your position that we can't rezone land in accordance with the council's spatial plan option C and D? D&E.
Yeah.
Because it needs to go through a Schedule 1 process. But with regards to KFO land, which is option F, you can zone that because you sought that in the submission to the plan.
Correct.
And so, in that sense, you're saying to us to ignore option F in the spatial plan sense and just rely on your submission to rezone land. Because if you've got a problem with D&E, you'll have a problem there under the spatial plan. So is it that the only, is your legal submissions that the only power to, the only discretion we have to recommend rezoning of greenfield land is in accordance with what was sought in the primary submission?
Correct.
Yeah. And that options D, E and F, because they are sought through the spatial plan and would have to be implemented through a Schedule 1 process, aren't available to them.
Correct. So the scenario D and E that are in the spatial plan, there's no scope for that.
But wouldn't F be the same?
No, because there's no submission.
Oh yeah, but in a pure spatial plan sense, F, the only reason why we can, I think what you're saying is the only reason why we could implement F isn't because there's something about F that's different to D and E, it's because F has a submission to the proposed plan. Is that correct?
I think so.
I mean, it reveals the difficulty of looking at the spatial plan if it's a tool that's supposed to drive.
We're really grappling here where we have legal discretion.
Yeah.
And we'll determine how fuzzy those lines are. But I was really trying to understand what you're saying, because if you're saying there's no scope for D, you're saying there's no scope for E, then it follows that there's no scope for F. But because you have an underlying submission seeking the same outcome as F, well, the actual zoning, because F sort of said contingency, blah, blah, blah.
Yeah.
But that because you have a primary submission seeking rezoning of F, we can have regard to that.
Yeah, that's an orthodox proposition, I think, that your power to change the plan is limited by the scope of submissions. You have a submission seeking to rezone the KFO site, which coincides with what's called scenario F. You do not have submissions seeking to rezone what is called scenario D under the spatial plan. And it is, I think it is quite, I don't think it's that fuzzy when you think about it that way. It gets fuzzy when you start thinking of the spatial plan as some kind of document that's meant to guide the PDP more than being a consideration.
And then your legal submissions go on to state, because the plan stopped, there's no immediate ability to notify variation until 2028. And I think what you're also saying is you want to sort of just keep ball gazing as to what that process might be. Yeah. Okay. I'm just trying to gel it down into a simple explanation that the planner can understand.
I suppose that reinforces that it's the section 32 analysis that's most important to what submissions are for the panel rather than the spatial plan. But I suppose the spatial plan is relevant in that it recognised the need for greenfields, and that in the HBA there was, in the short and medium term, housing unaffordability. And so even if you have technical efficiency under the PDPR scenario, PDR scenario doesn't solve the issue of housing affordability, and that's what the KFO submission does.
Yeah, just while you're interrupted, can I just take you back, and doing it while you're interrupted, take you back to your paragraph 64 in your submission? And you list there a number of matters that you say don't require, you submit, do not require answers at the planning stage. That's the legal submission as such. So are you going to address through your witnesses the effects or the impacts associated with not addressing some of those matters now or at an early stage?
Yeah, I think the witnesses will speak to those issues in more detail.
I mean, for example, transport uncertainty around how transport infrastructure will be funded, etc., etc. Yeah, it would be interesting to hear what evidence you've got, to support that.
Yeah.
And what are the effects of not addressing those matters at this stage?
Yeah, I think part 4 of the submissions kind of goes into that in more detail.
I'm sure there's more pages coming in. Thanks.
So I'll leave it to the submission.
Thank you for those explanations.
Now we're going to start through. I might just jump to paragraph 85, which is a reference to the Garden Trust and Council decision. We say this decision is relevant in that it contains guidance about the use of market preferences and understanding the sufficiency of development capacity. In that case, there were questions about the sufficiency of development capacity and how that would be provided in Waiuku, which is a township of 10,000 people. And like this case, the options presented were infill housing and then rezoning land for greenfield development. And it's paragraph 87, which just listed a number of factors that were relevant to the court's decision there, and the type of evidence that it considered to understand the sufficiency of demand. While there were parts of infill development, it was not dominant through Waiuku. The court heard and accepted evidence from witnesses that the limited infill was probably because people in Waiuku lived in Waiuku as a lifestyle choice and because of the larger sections, especially with old homes. There was a strong demand for recent greenfields development. The court heard evidence from a range of people, including builders and developers, who indicated that the existing potential within Waiuku was significantly reduced and that infill development was not appropriate or cost effective in such a place. Just included a couple of extracts from that decision, which I won't read, but at paragraph 88 we've submitted that many of these factors that influenced the court's decision in Garden Trust are present in Kerikeri-Waipapa, and the evidence of KFO's experts, in particular Mr. Corbett's evidence, speaks to some of these factors. And the last section is just about decisions about the integration of development with infrastructure. At 90, we've just referred to the decisions of 4-well developments, which were my friend's submissions, but a proposition that it is bad management practice to zone land development where necessary infrastructure to allow the activity to occur without adverse effects on the environment does not exist. I've just noted a number of other decisions that take a different view. First is High Quality Limited in Auckland Council. That was a consent decision. There was a Mexican standoff between zoning and infrastructure. And the court said at 32, this is a situation not unfamiliar to the court, and it is clear that a number of planning decisions and zones, including future urban zoning in Auckland, are subject to this very constraint. While the ability to provide infrastructure to any area may be properly justify being rezoned, it is difficult to see inability to provide the infrastructure as a full and complete basis to refuse rezone land, which is identified as future urban land. And then at 92, I've just added another case, which is Stonefield's decision. And then at 93, kind of a mediate position in Laidlaw, which is that it's basically a contextual approach. And Mr. Brown and Mr. Hughes will give evidence about how the transport effects of the proposal have been evaluated and managed. And Mr. Ellis will give evidence about the provision of freeways infrastructure. I've recorded a couple of questions the panel asked yesterday. One of them was, are the panel constrained based on absent infrastructure? And the response was no, there's not a legal ban. We would agree with that, although we fundamentally disagree with the proposition that there is an absence of infrastructure, and Mr. Ellis' evidence will speak to that. There was another question whether KFO could provide the infrastructure. The answer to that is yes. And then there were another series of questions about the impact of CCOs. I don't have necessarily a huge amount of detail to bring to that, but my submission would be that probably a neutral position in terms of the impact of the CCOs. That's fiction.
Part 4 now, Lloyd.
We are, thank you, sir. This is a detailed section, and it's where we really bring together the evidence with the advocacy, and instead of taking you through this in significant detail, given that the witnesses will be talking to you about these points, I might just touch the high points of each of the key topics. I'll leave this with you to read, but if I just hit the key high points, but if that's...
I think one of the other things that we'd be interested in is how has this proposal changed in response to 22A and the council comments. We did hear that there were some changes, particularly with regards to access.
Yes.
So we'd be interested to and I don't mind when you inform us of that, or whether you leave it to another witness to perform that task. But we are a little bit unsure as to what exactly is the proposal now. And then the other thing that we wouldn't mind getting some clarity on early is this question of staging.
Yes.
I asked a number of questions of council officers. Is there a plan showing where stage 1 will go and where stage 2 will go? And I think the answer we got was it was a reference to a number of plans primarily, but not necessarily a spatial layout. If that could be clarified for us early on, I think that would really help us be able to distill the evidence a bit better and focus our question.
Yes, well, why don't I just try to decide if there's a... Why don't I address that for you now, and then that may inform the discussion we're about to have of the evidence.
And yeah, I want to avoid a situation where we go, oh, you're supposed to do this, oh, we're not doing that anymore because we're doing that. Look, and maybe we just get that in our minds and and if there's something you picked up on the screen, that might be helpful too.
Yes, actually, there might be. Actually, if I could ask my colleague who's online, Emma Burns, to share. Mr. Neil's produced some. He's compiled some of the images that are present and all of the evidence that we could share on screen to help talk to this, and it does include a pictorial image that shows the precinct plan to reflect. Here. Lovely. Thank you, Emma. So this, if we could just flick through this, to just show each of the slides briefly. So that's the cover page. Then we have, and each slide shows. Yes, there we go. So the next slide shows the spatial area of the rezoning. Unfortunately, that red outline doesn't come up very clearly, but it shows the outline of the subject site.
Yes.
So
it's red on black.
Yeah, no, apologise. If we go to the next slide, please, Ms. Burns. Cool. Okay. That's attempts. You might get a better view of that from the air tomorrow, but that attempts to show it from the air to show the proximity of Waipapa Drive and Kerikeri to the site. Next slide, please. We will get to one that helps makes a point. That's looking from the other direction. Next slide, please. Burns. That's the waterfall. Next slide, please, Ms. Burns. Just in case some of the witnesses want to talk to you about that. That generally indicates the where the residential and mixed-use zone proposal is. Yeah. But if we go to the next slide, please. Okay. So this is what's been. This is the precinct plan for the development, and what it shows is the general zoning layout, indicative access connections, indicative locations for various features, the proposed natural areas to be protected, the east of the site, and one of the in terms of key changes to the proposal, essentially some improvements have been made to attempt to address some of the comments made by the 42A officers to the effectiveness of the provisions, particularly the matters of discretion in the comprehensive development plan. The change I mentioned earlier to remove the modification of the flood hazard overlay has come off, and the only other change is to reflect a practical reality, and that's that. And to be fair, it has been raised by the 42A reporting officers, and that's that despite long-standing and close engagement with the golf course, that remains third-party land that we do not have full agreement. We do not have agreement to access over. So what we've done is this. Well, this plan shows that as an indicative access route. It is an option, and it's an option that's still very much on the table and actively being explored. But it's not the only option to secure access, either by vehicle or walking and cycling into Kerikeri. And so that has now been, on this plan, that's been shown as, I think, indicative connection. But the proposal is still very much from the applicant to connect and ensure connectivity into Kerikeri. It just may not be by that route. And Mr. Corbett can speak to this, but for example, Whale Ridge, which is the grey area to the right of the green open space on the KFO site. Mr. Corbett can speak to this, but our understanding is that Whale Ridge is currently investigating a pedestrian cycling way across the river, and so it demonstrates the potential Okay, yeah, that's Kerikeri to do that.
So
So, yep,
access C and B and C
B and C.
are now indicative, because I don't think that plan says indicative, if I missed it.
It does, this has been modified to show that on this
Oh, okay,
image.
so,
Yes.
this was, because I'm looking at one attached to Ms.
Yes,
O'Connor's
yep, good
rebuttal.
point. That's a fair point. I think this will be an update that we
And this is an update of that,
Yes.
so this includes the indicative.
And so you might recall, you might have picked up from the evidence that B and C were never intended to both be delivered. And I think Mr. Collins addressed that. That's correct. It's a precinct plan that identifies connections that are to be explored and confirmed and addressed in CDP and by future development. So they are options, and they are options that are still certainly on the table. In terms of staging, you're correct. That's a term that was introduced through Mr. Hughes' rebuttal evidence, and it was essentially a way to describe the way the transport modelling had been structured to assess and consider. It was described as half, but approximately 3/4 of the residential development and about half of the non-residential development as a model scenario. And then stage 2 was the balance. There isn't a indicative staging plan, and Ms. O'Connor can speak to this in her evidence, but the provisions could be amended to address what is the intended reality, which is that sensibly developing the site would start from the left. Accesses D and A are entirely contained on KFO's land, and so are feasible and constructible, and I don't think anyone disagrees with that. So you would start from the north, you would have you would establish those connections, and you would develop down, and the reality is that you would. Yes.
I want to write this down.
Yes, of course.
So I've got this. So please just bear with me. So you're saying stage development would start from the north and relying on accesses A and
D.
D.
By total dry state highway.
Both accesses.
Yes. And so the CDP is the mechanism that's intended to drive this being confirmed, because it is an express requirement for the CDP to identify staging. And that's
So just to clarify that, and in defining, so you still have the roundabout there on State Highway 10.
yes.
That would obviously involve then, so the first stage would involve commercial land rezoning,
Well, I mean, that will be resolved through the
because you'd be driving through it, so does.
I think Ms. O'Connor's probably best to address that with you, but I mean, that will be resolved through the, yeah.
But it would involve crossing the floodway
Mhm.
to get to the other access.
Yes,
Yeah.
and, yep.
So essentially from the roundabout, I mean, I wouldn't say it'd be a border, but from the roundabout through the requested commercial zone land, whether that's zoned at that point in time is another question. Well, developed is another question. And then crossing the floodway and then up to access D.
Correct.
Do you want to speak to that anyone?
Yeah, should we get Ms. O'Connor up now, or do you want to defer this?
Yeah, well, I think we really want to understand what we, again, because I think it'll help our questioning
Yeah.
of you, if we really understand exactly what it is.
And also, if you can't get the access through the golf course land to Kerikeri-Waipapa, how would you do with that? But that may come later.
So yes, so explain the first stage.
There is no definitive first stage, but there are definitive access A and definitive access D, and that's confirmed by the transport model. Then the precinct provisions require, as we discussed earlier, you have to submit a comprehensive development plan with the first resource consent, and that's got a long list of assessments that are required to support it, one of which is to provide details of the staging of development. So just by way of an example, you could have stage 1 being residential development accessing through area D and no commercial, or you could have some commercial development and some residential development using XSA, or there could be a combination thereof. But the reason for this detail being required in the CDP is because at that time when it's prepared, all the other detailed analyses that are required to support that, such as urban design, etc., will all be done in a comprehensive manner. And depending on market forces and other factors, and depending on what land gets zoned or not, that detail will be provided through that CDP process and will refine those stages and relate the delivery of those stages to the infrastructure funding, which is also a requirement of the CDP. Because at that stage we will know what is happening, when it's likely to happen, and can have those detailed discussions with the council and align those things together. So that's the intention. And I accept the provisions may not be perfect, but that is how they've been written, and there's always room for improvement. But
Sure. We don't, as I say, I've got a better understanding there. More questions, more clarifying. Because it's really helpful. Thank you.
Well done. Always better to get the planner than the lawyer trying to be the planner. So yes, and so in terms of stage 1, stage 2, that terminology derives from the transport assessment, and it reflects really that.
Well, thank you very much for clarifying that. You can go back to, I think you can go back to your submissions. Yeah, I think that was really helpful.
Thanks, sir. So
Some clarification on that.
part 4, this section, as I said earlier, this section of the submissions addresses the evidence and relates it to the case. And I wanted to laboriously do this with you, mostly because I've used up more time than I intended to. But
This is a summary of what your witnesses are going to tell us.
essentially, and relating it to the board. So very much just touching the high points, I think, on economics. Mr. Thompson will address you on this in detail. As I see the proposition between the two key economic witnesses for this proposal, Mr. McElwraith describes there being a significant and deep difference between the two economists, and there are at some points. You know, I accept that. But I think when you look at the evidence closely, they actually agree on the fundamentals. The housing price of detached dwellings to be delivered now is significant. It's in excess of $1 million on both assessments. I think Mr. Thompson's about 1.1 million. Mr. McElwraith puts it at 1.26. So detached dwellings are quite pricey. There is demand. There is demand for growth, and there's significant demand for growth. I think on using Mr. McElwraith's assessment, there are currently 1,300 odd dwellings in Kerikeri. In the medium term, so within 10 years, that's going to increase by 1,320. So it's a doubling in 10 years. So there's a significant demand for dwellings. And Mr. Thompson's numbers are slightly different, but you know the point's the same. There's a significant demand for additional dwellings. There is, not much of that demand is for standalone, and I used those numbers earlier. 90% assumed by Mr. McElwraith, 85% by Mr. Thompson. And under the PDP, under the notified PDP, those prices will go up. That's where we get the number $1.68 million. So we're agreed on the problem. The economists agree on the problem. Housing's unaffordable, there's strong demand, and prices are only going to go up if something that is not done about it. Where they differ is on the solution. And I'll leave Mr. Thompson to talk to you about that. But that's where the dispute lies. Moving to productive land issues, in terms of the difference between the two experts, I think it has narrowed considerably. This is at page 39, paragraph 128 is where I deal with this, but the differences between the two experts seems to have narrowed significantly. There seems to be agreement that if irrigation is not a feasible option for the KFO site, it cannot be used for horticulture. And the evidence from KFO, which I don't think is challenged by any other evidence, is that irrigation is not feasible or practical at the site. Mr. Hunt can talk to you about that in detail, but that seems to be whether, at least in terms of productivity, where things boil down to. These issues are always difficult when the experts don't quite line up. Mr. Hill is a pedologist, Mr. Hunt is a botanist, always, but they can address you on that. The difference doesn't seem to be significant, at least in terms of that core, that's what we want. On flood hazard risk, the core dispute seems now to be in relation to what level of detail should be provided at this stage of the process. And I think Dr. Ricks asks for some additional information on some matters, but I thought it was quite a fair concession he made when he was speaking with you yesterday, when he said, look, this type of flood proposal and the components of it are the types of things we see around the country. And of course they are. It's a flood spillway designed and engineered to concept design stage. I want to be really clear, and Mr. Kuta will speak to you about this in detail, but this isn't an issue that the applicant is taking lightly. Significant work has been done by E2 Environmental and by Mr. Kuta to understand the hazard and to develop this proposal to the conceptual design stage. This isn't the applicant very clearly and very recognises the importance of managing flood hazard risk to manage the safety of people, and it's not the kind of thing that where the applicant is, or the submitter is just trying to gloss over. But Mr. Curry can talk to you about this in detail. Essentially, where things seem to be going now is if there is uncertainty, or if the flood spillway needs to be deeper or wider to accommodate the flows, that may take some land away. It may. Mr. Kuta doesn't think so. He thinks there is sufficient depth before we get to bedrock to build the flood spillway as developed in conceptual design. But if some land is lost and some yield is lost, that's not a problem for this project. In terms of ecology, again, the difference seems to be about exactly what level of information should be provided at plan change stage. And Ms. Andrews seems to want a description of all of the provisions that would apply to the site. And I don't think it's necessarily the role of the ecologist to identify which provisions apply, but I mean the answer is all of the provisions that the council has identified as being relevant for managing ecology through this plan, plus the NES freshwater and the National Policy Statement for Indigenous Biodiversity all apply. Wetlands will not be destroyed under this project any differently than they would be destroyed or modified under the NES freshwater. Those provisions will still apply. And indeed, the PDP can't make that otherwise. The NES freshwater is the national document. Provisions that are inconsistent in the district or regional plan need to be deleted. And so that's what I say about provisions. In terms of the concern about effects that may not have been assessed, watching the presentation yesterday, it seemed to focus around concerns about potential effects on bats from lighting, from the development. And whether provisions should be included in the precinct provisions to address those effects. Now, Ms. Andrews referred to the Peacock plan change, which was a plan change in Hamilton that was undertaken this years. And for your benefit, I was very closely involved in the process, having acted for one of the key parties. And the key thing you need to know is that yes, provisions were included in that district planning process to manage effects on long-tail bats from light sources, but that was after, through consenting processes, that a significant population of long-tail bats were found to be in the area, and the council took the step of identifying corridors as significant bat habitat areas, which were then protected from light. It's not a case of protect every bit of vegetation from light, even if we haven't found that within 25 kilometres. And so there's a very, I don't think that plan change can be used as an example of why you need lighting controls at this stage, at this time. Turning to infrastructure and Three Waters, Mr. Ehlers will be able to speak to you about this issue. And the basic proposition is that the buried away in one of the appendices to the 42A report is the OPIS report, which confirms that Three Waters servicing is feasible for this project. The question really is about funding and infrastructure funding. And I think this is quite an important issue to deal with. The evidence and the 42A report express a narrative that this land may be rezoned, and then the developer or the developer may put its hand out, or the council will be forced to pay for the infrastructure bill. That rezoning this land means that the council has an obligation to fund and deliver the infrastructure that will be unaffordable and that will be unreasonable for ratepayers. Firstly, that's not how land development works, and I think when you actually interrogate greenfield rezoning, that isn't how things work. These provisions are designed expressly to not have that happen. The CDP provisions require demonstration of our infrastructure will be funded and provided. And that will need to be done by the developer in collaboration with the council, but very squarely intended to be funded by the developer. There's a repeated narrative that no binding commitment has been given by KFO to meet the funding costs of the or to fund the infrastructure. I'm not sure what the council expects would be provided at a plan change stage, a blank cheque or I'm not sure. But Mr. Brownlee has given evidence as the corporate representative on behalf of KFO saying, you know, and we intend to meet our infrastructure costs, and he's been advised that the provisions provide that. There's no intention that we're just going to build the internal roads and then say to the council, where's the water, wastewater, what are you doing? That's not what this proposal is about.
While we're here, then, is it the proposal that, because I think there was some discussion somewhere that it could connect to some of the capacity in the wastewater system, and then this question of area of benefit, who's first in the queue to get that, and does it displace? So is that still part of the offer, that if there is capacity, AFO would like to use it
and pay for it,
or do they concede they're the last cab on the rank, and you're going to have to provide your own?
No, the proposal is our intention and the KFO's desire is to work with the council and ensure that any and all infrastructure upgrades are taken into account its development, and that it funds its proportionate share to that, including articulation and capital works upgrades. Yep. Yeah. And that's the infrastructure proposal that's been identified as being feasible. I think it's a very dangerous and slippery slope to start thinking about assigning priority as between two rezoning proposals, as in to say, well, PDPR is the council's proposal, it gets priority to connect, the KFO proposal doesn't. The proposition is that infrastructure can be provided and KFO will pay its way. And on that, there was...
Having said that,
yeah, yes.
If you accept that Waipapa has no articulated infrastructure,
of course,
and you do start your, potentially, does start in the middle, that would be a question that would probably answer that question.
Absolutely, and it would
seem, if you were going to connect, it would make sense to connect
in
the southeastern section.
Nice. Yeah, potentially. And I mean, again,
maybe this one of the witnesses could confirm that later.
Mr. Ehlers can talk to it. I'm not sure he's online yet, but we'll ask him to address that. There are a range of options that he's looked at, and one of them is dealing with wastewater servicing capacity on site first, for the initial stages. And then if and when, or then working to build the reticulation network. And there are a number of benefits. I don't want to get into the engineering too much, but there are benefits of doing that. One of the points that Mr. Hensley made is that if you connect wastewater capacity but don't have sufficient flow, you get septicity issues. And so, working with the council, there are various solutions to do it. And the point is feasible, will pay away. And I think the council's meeting at the moment on its development contributions policy, which it may or may not adopt, and which may or may not. Then also provided a formalised framework to do a private developer agreement to feed into that capital works funding as well. But yes, Mr. Evers is your man probably on that. In terms of funding, Mr. Hensley did have an unusual sentence in his evidence where he estimated that the infrastructure cost would somehow get to $400 million if you put the hybrid approach together. But I understand from his discussion with you yesterday that he admitted that was an error, that sentence, and he's deleted that, which is good and is appropriate, because I think it was just adding the two together, which assumed you build 2 wastewater treatment plants, 2 water treatment plants, 4 pump stations, and double the reticulation, which obviously isn't intended. Okay. With transport and connectivity, I have addressed that with you briefly, and in terms of what the intention is to ensure connectivity, and it's the modelling has been done. Mr. Brown and Mr. Hughes will speak to you about Mr. Collins' comments about the model inputs when they appear this afternoon. They can take you through the rationale to develop those inputs, having regard to the particular features of the site and the locality, rather than using wider national inputs. But Mr. Brown and Mr. Hughes, you're in for that. What the modelling tends to show, from my understanding and from the evidence, is that the proposal is serviceable up to at least at stage 1 with either 3 or 2 of the connections. With 3 connections, there are some difficulties as you get into Kerikeri Township, as one would expect, that being an area where there is congestion, particularly in the A and G peaks. But it shows that the intersections are serviceable with a two intersection solution being the Waipapa and State Highway 10 connections. And so that's what has been the genesis of the proposal to say, rather than being uncertain about it, the reality is that it is probably better to deliver those connections first and deliver the next connection when it makes sense to do so. And that's the point. And the golf club, I understand you had a presentation yesterday from the golf club, and regrettably I was travelling at the time, so I wasn't able to view it. And I've tried to catch up very briefly online just now on the recording that's been posted. But my understanding is that the people that spoke to you yesterday were not authorised representatives on behalf of the golf club committee or the golf club itself. And so, yes, you have to have regard to its submission, but I think you need to be quite careful in taking the views of 2 people as being representative of the whole golf club. And I have an email here from the golf club chairman that I don't want to get into
real golf club, please stand up.
Yeah. Well, this is the point, right? The golf club has to vote 75% on any proposal that is made.
Yes, I think they said it had to go to committee for us to go out to the site, was it?
I had to go to committee. Yeah.
Okay, so look, I think what you're explaining, and all jokes aside, is that it's a comprehensive entity, and it doesn't speak necessarily with one voice, it speaks as a committee, and we should be aware of that.
Yes,
So, yeah.
that's the proposition, and I have this email if you'd like it. I can have to give it to AK for completeness, but I mean that is the proposition. And if anyone's ever been on a golf club committee or a
In that sense, then, do we know what their position is at this point in time?
As Mr. Corbett can speak to it, he's been leading our engagement with the golf club over a long period of time, but my understanding is of the position is that it remains willing to work with us, with KFO, to find a solution that can be agreed on and can be put to the members for a vote, but they can't adopt a position beyond that.
And so this email was from whom?
Mr. Webber, who's the chairman of the executive committee of the golf club.
And has he authorised to make this statement?
I don't know. I don't know.
But I mean, we could possibly get another email saying, hey, he doesn't speak for us.
Can I just comment on that? Evidently, he sent comms out to the rest of the executive committee before that was together. So committee agreed for that to come out from the chair.
So it seems to me that what this sort of says is we're not opposed, but we're not agreeing. You're in consultation.
It had been for a long period of time.
And anyone who says, I like it or I don't like it, aren't speaking on behalf of the golf club.
And ultimately, the golf club will need to vote before its position is fully known. And that's the difficulty of dealing with golf club. Try being a member of a committee of one, not advisable.
Is that reference to two people? Is that meant to be a reference to the two people that spoke to us yesterday?
I understand so, yes.
Yeah, that's not the same.
It's not the same thing.
Yeah, it's not me, sorry, so I'm sure it will.
No. Graham Brown and David Neal.
Well, I mean, I think it probably you can take two things from it. The executive chairman wasn't aware of people being authorised to speak, and he wasn't even aware who was actually coming to speak to you, which reveals something else. We don't want to make a big issue of that, obviously, for you, but I think you've summed it up well. The golf club speaks to the golf club, not any one. Okay. Look, urban design, again, Mr. Neal's best to address you on this issue in detail. There seems to be a philosophical difference in approach between Ms. Rennie and Mr. Neal, and I'll let him address it. But my submission to you is that to achieve, I think it is really difficult to leave it to the market to achieve great urban design outcomes. I think my submission is you see that, you've seen that with historic development that has just been allowed to occur, and what the difference between the PDPR and the KFO proposal is that the KFO proposal has a CDP requirement which anticipates and has been enhanced by better urban design input to enable it to provide for better placemaking. And that's really what the KFO proposal is trying to achieve through that urban design input into the CDP process before development. And Mr. Neal can address that in detail, but I mean the counterfactual is a rezoning for the PDPR that contemplates 4-storey apartments in the town centre zone and 3-storey apartment or 3-storey townhouses in the medium density residential zone as a permitted activity if you meet the BEAR height relation to boundary yard height requirements, the BEAR standards. And it seems that Ms. Rennie's position is that because it's already in the town centre or it's already in Kerikeri proper, people will just do a good job of integrating with the surrounding environment. Just it's okay, it's nearby, they will do the right thing. I think it's an evidential comment that you need to be quite cautious of. It's not about, despite what I just said, it's not about comparing who will best deliver or who's going to do the best urban design outcome between the two of those. But the proposition is that the KFO site and the way the provisions have been structured will enable very careful and very close engagement on urban design issues to ensure great outcomes.
Just on the matter of urban design, yes, your witness can be. Your witness will be able to expand on this, but that last sentence, that paragraph 185 of your submissions, village maintaining the village feel of Kerikeri and design in a way that is unique to the Northland context. That's pretty important, and I'm keen to understand how that comes through the CDP requirements and matters of discretion and all that sort of thing. So he's just interested in that aspect.
Of course, now I think there's two elements of it. I think it's both what is done on the KFO site under this proposal, and it's what happens to the rest of Kerikeri village as it currently exists. And it is interesting that after your engagement with Ms. Reddy yesterday, I did look back at the spatial plan and the PDP and to try and find a clear statement of Kerikeri's character. It's something that the spatial plan talks about wanting to preserve and protect. It's very hard to find a pinned down statement of its character. I think Ms. Reddy's point was we're working on it. It hasn't been defined yet, but Mr. Neal can talk to you about what he perceived as is that pillar of character that the community say they need to retain.
I wonder if the structure plan document has anything in there that you guys have prepared, have talked about it as well, that you can hear from your experts.
Yeah, Mr. Neal is one of the co-authors, is probably best to talk to that.
Okay, thank you.
Okay, that gets us to the end of those points in part 4, and really the conclusion is, as you would expect, we say that the evidence for KFO demonstrates that the rezoning is both necessary and appropriate to ensure that the PDP gives effect to the MPSUD by enabling affordable housing that's responsive to the market's preference for attached housing. The current PDPR is misaligned with market demand and community preferences and relies heavily on infill and attached typologies which have historically seen little uptake and which fail to provide for affordable detached housing at the scale required. In contrast, the KFO proposal offers planned greenfield development that can deliver a genuine mix of housing types at price points directly addressing affordability challenges and supporting the well-functioning urban environment. Concerns regarding flood risk, ecological effects, infrastructure funding have all been addressed in expert evidence, and we would say to the standard required for rezoning stage. We say that the KFO proposal satisfies the requirements of the NPSHPL with the benefits of rezoning outweighing the costs of losing the Class 3 soils, which have limited production capacity. Ultimately, we say that it represents a prudent and responsible approach to urban growth in Kerikeri-Waipapa. It aligns with the objectives of the PDP and supports the well-being of the community, providing flexibility and capacity for future growth. Just one other legal point to touch on. You asked my friend to address you yesterday on what happens when the government does finally release its changes to national policy direction, which is expected at the end of this year. And my learned friend knew that depending on what's in the transitional provisions, you will need to give effect to it, and that will be an obligation that you have from that date. So, if that changes, you're going to need to respond to it. And it's not a great position to be in, given the anticipated timing of the roads being at some point before the end of this year and a decision early next, or a recommendation early next. We will need to respond to it when it comes out, and it may be that you do wish to call for evidence or submissions depending on the nature of the changes.
What we were discussing is, if it happens around Christmas time and early in the new year, we would have scope to put it in our reports, and it would be not just this submission we'd be having to address.
I mean, it affects much of the plan, doesn't it?
Yeah, it would. Around a very tight timeframe imposed us, both the council and us. However, by the government. However, if the government comes along and shifts the goalposts along the way, then it may make it grounds to seek an extension of some sort, particularly to receive further expert evidence and or engagement that may or may not be available to us. And possibly the worst scenario is that it lands somewhere between our recommendation reports being submitted to council and council making its final decision. That would certainly create an issue. But we just don't know.
That's right. we just have to respond to it as it arises, but,
I think the government's grappling with priorities itself. We're just not sure where NPSHPL sits in this priority. Just one other question, if somebody could somebody update us as to where you are with NZTA Waka Kotahi? They do have a submission.
yes.
They do have evidence here. I don't think they're planning to appear.
Okay.
But we have their evidence. If somebody could update us as to where I suspect we're talking with them.
Yes, I'll find out on where that's at, and either one of the witnesses can update you in a spec, or I can update you at the end, find out where that's at.
Yeah, thank you. And so we're now moving into witnesses. I'm just thinking when we have a break for lunch.
Where are your hands, sir?
I think what we'll do is we'll box on until around about 1, and then we'll have a wee break there.
Thank
And
you, sir.
here's the thing, there will be a number of, some of your witnesses, we may not have many questions for, others we may have a few, so.
Thank you. And last, I think we generally haven't asked the witnesses to produce summaries to hand out, because it just does take a long time for them to introduce significant new material. But most witnesses will just speak very quickly to their high points of where the key issues are and where the issues remain. And then yes, we'll be very glad to ask questions. So we'll just start with Mr. Brown. Now, Mr. Brown hasn't produced a summary, he just has speaking notes for his own use. I'm just asking to introduce you now or to continue now.
I'm Steve Brown, Managing Director of the Kiwi Fresh Orange Company. Our vision is to develop a preeminent housing development that adds to the great features of Kerikeri, the Bay of Islands and the far north, making them an even more desirable place to live and to come on holiday. As a bit of background, Kiwi Fresh Orange Company is a family-owned business located mainly in Hawke's Bay. Our main business is growing oranges along the east coast of New Zealand and producing fresh juice for the New Zealand market and Southeast Asia. We are the largest grower of oranges in New Zealand and have a dominant market share for fresh juice domestically and in Hong Kong, while expanding rapidly in other markets. We look to expand our growing presence into Northern around 2010, and we were introduced to part of this property. While we were aware it was likely to be marginal for growing oranges, it was obvious to us the property's potential to be developed into an ideal housing location with its proximity to the Rainbow Falls, Natural Bush, the Kerikeri River, Waipapa, Kerikeri, the Bay of Islands. With further investigation, it became apparent that the site would not be suitable for growing oranges, due mainly to the lack of irrigation and weak clay soils. So we simply leased it out to dry stock farmers. In 2018, we were approached to see if we had any interest in purchasing the remaining half of the property. We had discussions with the golf club and other property developers and decided to proceed with the purchase. Since purchasing in 2018, we have been having a lot of discussion with the community, coordinated by Dennis Corbett, to understand fully the potential for the property and how we could play a part in the future of Kerikeri. It has become clear to us that we have a lot to offer, and we developed in conjunction with Ngāti Ria our plan for Te Pai Waiora, connecting the fall's character and amenities for the community's well-being. I understand Kerikeri and Waipapa are the largest commercial centre in the far north, therefore providing housing and economic growth for the area is vitally important. And we believe, after many discussions with our team of experts, nobody is better suited to achieve this than us. We can help maintain the unique village feel of Kerikeri. We create connectivity between Kerikeri and Waipapa, allowing access to the Rainbow Falls area and its natural features. Large areas of flat land suitable for a wide range of housing, including affordable housing. Potential for a much needed hotel in the area. We hope to be able to work with the Far North District Council to make our vision a reality and make Kerikeri, Waipapa and the Far North an even more desirable and affordable location to live and holiday in.
Okay, thank you. I recall you gave similar evidence to us way back in hearing one, is that correct?
Oh, I didn't actually give it to you.
It was presented.
Right,
Yes, well, welcome back. Okay, thank you for that.
No, it's the fact that we've heard some of that before.
Yeah.
Thanks.
Just one question on the precinct plan. There's a notation for a potential school site. Is that something that you see a need for there?
I'm not an expert,
Yeah.
but I'd say that could be a good option. We're open to that.
Yeah. Okay. Sort of just flagging it as an option. You haven't really taken it too far at this stage.
No.
Okay.
Yeah, other than just identifying spatially, if that was an option that the Ministry for Education wanted to pursue, we are on the precinct plan, maybe a sensible location.
Yeah, maybe one question for you. You said you've been running dry stock on it. Has that been a reasonably successful operation? Does it work for dry stock?
We've leased it out to dry stock farms. And they paid the lease, so
Yeah.
it's been successful.
Okay. Very good. Are you able to answer questions about irrigation, or is that best to your productivity?
It's probably best for them, but I'm prepared to answer.
What I'm interested in is whether the site isn't currently irrigated or can't be irrigated, or is it something else? I'm wondering. It seems to me that irrigation is a critical component of your LUC Class 3 viability, and I'm just wondering, is it because it's not connected, or it needs to be connected, and is there not enough volume, or for some reason it can't be?
The cost, I think anything could be connected to irrigation, just the cost of doing it is not viable for anybody.
Okay, so it's available but uneconomic, would that be fair?
Yeah, not easily available, uneconomic.
Thank you. Thank you very much for your evidence, and I assume you'll be here for the rest of the presentation.
Thanks.
Thank you, Commissioners. I'll now get the report going to do essentially the same.
Good morning. Just before I start, I was just covering off on one question that you asked Mr. Brown. I have had high-level discussions with various educational experts in the area, not outside of the area, and they'd be very interested in proceeding further. I've also had high-level discussions with hotel developers and suppliers of supermarkets. So it's all been high level, but there is strong interest. In my summary of evidence, I'd like to cover firstly community consultation and engagement. KFO's proposal is the result of more than 5 years of consultation by myself with many groups, businesses, organisations and Ngāti Reo. I've regularly had meetings with the community groups and individuals, facilitated meetings to bring different groups together. The community has always been kept informed of anything that we've proposed, and this has evolved from and will continue to have collective input. The outcomes of community consultation and engagement have been very encouraging. KFO has received overwhelming support from Ngāti Reo, who bestowed KFO's proposal with the name Te Pai Waiora. KFO has received overwhelming support from community groups that the proposal meets Kerikeri-Waipapa's needs in regard to housing, connectivity, services, cultural, employment opportunities and general community wellbeing. The proposed development has been planned and well implemented to best meet the community needs. As far as market demand goes, as per my submission evidence, I have over 20 years experience in real estate around Kerikeri-Waipapa and also the wider far north that has involved residential, lifestyle, coastal, subdivision development, commercial and business sites. I asked, what is it that attracts people to Kerikeri? It is definitely the lifestyle on offer, the open space, nature, culture, history, water activities, walking tracks and village type atmospheres. If there were a demand for high density infill, it would already be on offer. The market demographics is made up of three groups: young families, retirees, and lifestyle living. Firstly, the younger people, their preference is for affordable standalone housing on 600 square metres to 1,000 square metres that is located reasonably close to amenities and recreational activities on flatter land. The price range that for them to become affordable is 600 to 800k. That's land and house. The next group are retirees. A smaller lot housing of 600 square metres to 800 square metres of standalone housing or duplexes that are located close to amenities such as healthcare, shops and recreational facilities. The price range that the most of this group are in is 800 to 1.2 million. Then there's the lifestyle living, those that come here for the larger lots of 2,000 square metres up to 6,000 square metres, and they're in the price range usually of between 1 and 1.4 million. In my experience, prospective buyers do not come for city type living in a lifestyle area. Prospective buyers come for the lifestyle, nature, culture, history of the area. None of these three main categories are looking for apartment or terraced housing. There is simply no demand for it. Buyers would need a significant reduction in price to what is proposed in the PDPR option in order to compromise what they want in a home. Unless infill development can deliver homes at a noticeably lower price than other affordable options that meets buyers' preferences, there is likely to be little or no demand for such infill housing. The next point I have is what's the interest from developers wanting to build apartments or terraced housing in Kerikeri? The biggest demand, I'll say again, the biggest demand is for standalone housing of 600 square metres to 1,000 square metres that is close to amenities and recreation facilities in that 600 to 800 range. No one in the market has shown any interest in apartment or terrace housing. And when asked, the response has been no thank you, or a great look of disbelief. Regarding the proposed district plan, our option, there has been genuine surprise about where this scenario has come from. Having spoken to many locals, Pati Ramaka from Ngāti Ria on the 22nd of September, community groups representative Rob Mueller on September the 19th, Councillor Steve McNally the 24th of September, and more recently Councillor Ann Court on the 5th of October. The sudden pivot towards intensification is misaligned with community preferences, and for everyone has come out of the blue as a complete surprise. And just in conclusion, the community want and urgently need affordable housing and amenities in a local location, an ideal location, and the topologies people want. Well-planned growth of Kerikeri-Waipapa has been strangled for far too long. In my view, the KFO proposal offers housing types that people actually want. Thank you.
Oh, thank you for that. And so you're a real estate agent with quite a bit of experience in Kerikeri-Waipapa. That's correct.
Yes, a previous business owner. I sold my business
not
so long ago. Offices right through the farms.
Yeah, so you've had experience in seeing how Kerikeri has grown and changed over the years.
Certainly, yeah.
We're staying at the chalets, literally just stone's throw down the road, the Kerikeri Chalets, and and out walking about, I where are the development in Te Arapu Lane?
Tiuru Lane?
Yeah, that's
Yes.
just
Yes,
down
I am.
from here.
Yes, I am.
And so I sort of asked the question of council officers, is that what you're looking as for medium density? And the answer was, yeah, that's the sort of thing that the medium density zone would enable. And I understand that's a housing for habitat development. Do you
Yes.
know anything more? So
Yes.
I would think that would be, so there's no demand for terrace housing, but I think that might be an example of terrace housing at an affordable price point.
That
It
was
seems to be fully occupied.
for a specific reason,
Yes,
habitable housing.
yes,
It wasn't a development that was built for the market.
right, okay. So you're saying that if it was at market price, it wouldn't be affordable?
If it was market prices, it wouldn't be fair.
Yes, okay. Are there any other examples of that sort of thing happening in and around Kerikeri? I think there was,
Like Tiuru Lane?
yeah,
Not that I'm aware of. There are other developments of larger lots, of course, much larger. The price point of Tiuru Lane, it dropped, the starting point was 695,000 for land house package on a very small lot, 300 square metres. And they go up to 1.2 million or 1.1 million, around about that.
I'll see if the other commission, thank you.
Sure.
I think it's all pretty clear. I guess just what you see the vision to be on the KFO site is 600 to 1,000 sort of square metre size lots with standalone dwellings on. Is that kind of what's in your head, what the market wants?
Yes, but we had the opportunity because of the size of the development to cater for all of the segments, the three segments I've just read here before, like the affordable housing, 600 to 800, and then maybe a little bit larger sites or similar size sites for retirees that are standalone with maybe a few duplexes.
Yep.
But then also we can cater for the 2,000 to 4,000 square metres that housing might like closer to perhaps the golf course and the bush walking area.
So that's the mix of things that you
The
do.
mix of things. We want to be able to cater for the whole mix.
Yeah.
But
600 is kind of the lower on the most dense.
that's where the market is.
Yeah. No, that's clear. Thank you.
And just to finish off, my involvement has been one obviously with the community and 5 years of working with the community. So this isn't Mr. Brownlee's idea of development, it's the community's idea of development. And we're determined to deliver.
How do you actually provide for the affordable housing? You know, when you talk about 600 to 800K, how can you be sure that you can provide that in due course?
Well, the land cost in this such a large greenfield development, the land cost is a lot lower. And there are now, my son is actually a builder, so I'm working with him on what could be built, the size of, and we believe that we can meet those target prices.
Your evidence was really useful in terms of the pictorials of the golf course, in terms of supporting some of the evidence we heard yesterday. It was quite useful to have that. That development in Te Arapu Lane, that we're all become familiar with in the last few days, is that the sort of thing you could build on an affordable housing basis, or is that beyond that?
Those are a little larger. I think most of those are around 100 square metres to 140 square metres. Similar. Some of the designs, thinking about it, that we've sort of put together so far are very attractive designs. Those are probably a little more appealing than what those ones are down there, actually. They're very standard. We're not wanting it to be all the same.
Because you actually mentioned that in your evidence as I recall anyway. Yeah, thanks.
Okay.
Mr. Chair, perhaps I think maybe there's a little confusion of the sites before Mr.
okay.
Sarah,
I think,
just for clarification.
Just for clarification, I believe the panel is talking about the sites located further down Kerikeri Road towards BP.
Yes,
And Mr. Corbett is talking about the sites to the south of this building, just next door here, is that correct?
I was talking about both sites, to Urban Lane, but also the one down here that was my housing.
yeah, I was referring to the habitable housing, which is, yes, literally, I think it's one property up from the BP and opposite,
Yes.
Flooring Extra.
That's right. I'm sorry, I thought you meant the to Urban Lane as well.
Yeah, sorry, so it's out of two lane.
Okay, that's a to Urban Lane.
Yeah, okay, so sorry. Well, let me put the question to you. That one.
Yes.
Yes, right?
Yep.
Sorry, that's a little bit, it's the easiest way to mention it. So I understand that's the housing for Habitat,
Yes.
and that's a terrace housing development,
Yes.
two-story walk-up. And so my question to you was, it seems to me that that was what council was looking at in terms of enabling through their intensification zoning. And I just wanted, your comment on its viability as an affordable housing option as well.
I wouldn't be too sure. I don't think so, because the preference with everyone that's wanting to come into the area that we can't accommodate at the moment is standalone single area.
So when I had a look around it was fully occupied and, 2 cars in each garage. And
Yeah.
so it seemed there was a market for that, perhaps. Or is it just because of its habitat, its price point was deliberately low? Is that your evidence?
Well, I believe that they rented.
They rent, yeah.
I don't think they were sold.
Okay, fine.
Yeah. And, I don't know whether anyone might buy it.
Thank you. And I put that question to council officers. I wanted to put it to.
Sorry, I was a little confused earlier. I didn't answer.
Yeah, that's right. I think we've clarified that up now.
Yeah.
But thank you, Mr. Will, for pointing that out.
Yeah, it's Trender actually. I give you credit.
And feel free to, I've gone off on a tangent, just feel free to jump in.
We have 3 minutes, and I think Mr. Thompson might be longer than that with you.
Yeah,
I'm trying
I think
to
so
break
too.
now, or, yeah,
Yeah, let's call it 1 o'clock, take 45 minutes,
thank you.
and we'll be back at 40.
Okay, stopping the recording. And